So, and I have another question to Dr. Sri Ram sir. So, as a carries vision assumes that IP rights can be effectively enforced. From what you see in digital marketplaces, where does that vision collide with enforcement realities on platforms?
Thank you, Gauri. Yeah, so as Carrie said that IP rights are enforceable, yes, I completely agree with him. Now let's answer this question from the perspective of a digital marketplace. I think that to answer that question from this perspective, the answer needs a slight modification. Because the digital marketplace, as I believe, is a completely different animal, and to enforce your IP rights on in the digital world is a completely different ball game. So it was not like you are going after a physical, you're going into the physical marketplace and identifying an infringer or the source of the infringing products by way of an investigation. It's still easier comparatively. In the digital marketplace, it is such a big ocean that you do not know most of the times you don't know where the source is. There are so many URLs, there are so many listings, algorithms that are being used. Technology, as much as it is being used to identify where the source of infringement is or where the infringers are, it is also helping the it is also helping the infringers likewise. So there is not one single bad actor. Sometimes you don't even know where these people are sitting. So yes, so if you want to enforce your intellectual property in the digital marketplace, it requires that extra diligence, the extra steps that you need to take to ensure that there is no recurrence of infringement. And technology, of course, platforms and the digital marketplace does help you out with all these things, but then the brand owners and the lawyers also need to be completely aware of not just the procedures, but a harsh reality and a harsh reality which says that you cannot stop after one action. You cannot just fill up a form and then stop. You need to be extremely vigilant about recurrence and the same products coming back into the digital marketplace by the same actors or by someone else. So the entire ecosystem of enforcing intellectual property on a digital marketplace, to come back to the question, Gauri, yes, you can enforce it, but then it requires that those extra steps in vigilance from your side.
I have one follow-up question to Sri Ram sir. If IP is becoming a business asset rather than just a legal right, should founders rethink how early they invest in enforcement and compliance? How early the founders will think to invest in the enforcement and compliance?
Well, to tweak your question a little bit, if you the one aspect is how early should the founders invest in compliance, and and in reality, how seriously are the founders taking this? So, yes, IP is a very serious business, and the founders should take it up very, very seriously and invest in this compliance at a very, very early stage. Obviously, once they are very, very sure about what they want to use as an IP, say for example as a trademark. So even to look for a trademark, even to come zero in on a decision on which trademark they want to adopt for their business, either as a trade name or a brand name for their product or for their service, there is a certain amount of investment in terms of time and money that they should consider. Some of the mistakes that founders, at least the early stage founders, are making is that they probably want to avoid these steps to cost cut. But then that's not advisable. The founder it is like spending 100 rupees to save 10,000 rupees in the future. So it's a part of your diligence. It's a safety net that you build around your business to ensure that you are adopting the right kind of IP and you're working your business around the correct IP. So yes, the founder should invest at an early stage, and they should invest time also before they come down to a decision on what they want to start using.
We often hear that platforms are protected as intermediaries. From what you have seen in courts, is the real question. Today is less about labels and about more about the conduct, right? So, what do you think about it?
Yeah, if I have to give a one-word answer to what Gauri just asked, yes, it is more about the conduct. And there are two aspects to this. Now, platforms have certain grievance mechanisms, like they have certain copyright grievance forms, trademarks for domain names, etc. So where infringing and counterfeit products can be identified, and the brand owner or their lawyer should go and take those steps and fill up those forms. One is the grievance mechanism and the existence of that mechanism in itself. The second issue is the conduct of the platform once those steps are taken diligently by the plaintiff. Now, courts are very, very seriously considering and looking into the conduct of the platforms post notice or post the action is taken. And it is not just the existence of a grievance mechanism which is very, very relevant in today's day and age. Now, just to take an example, Amazon, for example, has one of the it has the gold star of grievance mechanisms. But in one of the decisions, for Amazon to be labeled as an intermediary, it was unable to prove that it is a mere intermediary, and the safe harbor defense was not available to Amazon, despite having one of the best grievance mechanisms. So, because the courts are now looking into what is the action the intermediary is taking. Has the intermediary actively participated in the infringement? Has it facilitated the commercial transactions? Has it, despite being made aware, been very, very passive about this whole thing? So these are the issues that the court is taking. In fact, it's not the evolution of technology itself which is bothering the court. So, for example, very, very recently, the Delhi High Court also in a couple of decisions directed the domain name registrar, which is the National Internet Exchange of India, to cross-check KYC details of the domain name registrant who was actually applying for an infringing domain name. So that is the extent to which the courts are going. So, and there's another decision, which is a very landmark decision which involves India Mart. So India Mart does not really have one of the best grievance mechanisms, but it has a very, very, it is not even very IP specific, if I am not mistaken. But then it has a very general procedure which any aggrieved person can follow and bring it to the attention. But India Mart's conduct was so prompt, post notice and post being brought to attention about the infringing products, the plaintiff was Puma in that the court gave India Mart the benefit of safe harbor under the Information Technology Act. So it is the conduct of the intermediary, it is the conduct of the platform which weighs heavier than the actual existence of the grievance mechanism or what are the procedures that a brand follows before approaching the court.
So, if the intermediaries are taking this kind of precautions that the counterfeit goods cannot be sold on their platform, and if they incorporate some more advanced tech to verify it whether it is coming from the right source or not, definitely it is very important. Sometimes the platforms are worked as a neutral platforms, and in that scenario, what is your thoughts, sir?
See, neutrality is a defense. Neutrality is not a permanent status. Okay, you cannot stick to that forever. So, if I have to answer your question in just three lines, I will say the first instance at which you are informed about the infringement, staying silent at the first instance may be passed off as ignorance. The second instance, yes, you can say it is a delay. And the third instance, I would rather say it that then the courts will definitely step up and say, you are not just the road, You are allowing, you are now allowing rash driving on the road. Right? It's to put it in from a traffic perspective, because since we are sitting in Bangalore, and which is notorious for its road and traffic situations. So I said that it's not just, it's not a permanent status, then you can sit around and say that, okay, I am neutral and I am not allowing it. You have been informed about it. You are now aware of it. All the necessary procedures have been followed. And after that, what are you doing? Is what the courts are going to definitely ask the intermediaries. And now the intermediaries cannot anymore take the defense that they are, or take the benefit of Section 79 of the Information Technology Act, which talks about safe harbor. Just to give you another example, there are two decisions most of the people here will be aware of, which involves Google. One is one of Madras High Court, which was passed in 2013. Another is just 10 years, fast forward to 10 years, 2023, was passed by the Delhi High Court. At that point of time, way back in 2013, Google was able to prove that it is an intermediary because it was not actively involved in the infringement. It was not actively, it did not facilitate any of those things. Now, by the time a similar situation came up before the court in 2023, amongst like inter alia various other factors, the court was also more attuned to the technology and the developments around it. But at that point of time, both the cases were related to keyword advertising. So by that time, the court was more confident, and in fact, Google was not given the safe harbor. So with the evolution of time, evolution of technology, and with the benefit of technology, which both the plaintiff and the defendant, both of them have, it is becoming more and more difficult for platforms to say that, no, I am not involved in this and I am just an intermediary. Yeah.
So in case of Google Ads, suppose Google Ads is incorporating some keywords which are having trademarks. And in that scenario, what do you suggest, whether the Information Technology Act will prevail?
Not necessary. Like as I said, it entirely depends on the conduct of Google in that. It entirely depends on how much Google has facilitated, because when an infringer, or say for let's not call him an infringer, when a defendant wants to use a certain brand as a keyword for his own advertisement, it will definitely apply with Google. So what are the safety measures that Google is taking to ensure that this is not an infringing brand? What are the safety measures that Google is taking to, after being, okay fine, but after Google is being told that this is infringement, what are the steps that Google has taken will be considered by the court to facilitate the argument and to give the benefit of being an intermediary to Google, or for that example, any search engine. Why just Google?
Yeah, sure. So I have few of the connects, and I know that there are few startups which are helping to track the trademark infringement through URLs. Okay, so whether going to these kind of startups will like enhance your search, trademark infringement search, and reduce your time, what do you suggest?
See, there are two ways of looking at it. Are these startups identifying in general which are the trademarks that are infringing to your trademarks, or are these startups, if you are giving a certain, if you are bringing a certain URL or an infringing activity to the startup's attention, or say for example this particular service provider, if you are bringing it to their attention, are they helping you in identifying the source of that? Yeah. So I would say that I would say that I'm pretty sure that if these kind of like for example, as far as I am aware, Amazon, Google, Flipkart, or even Meesho's and all these online platforms, they have their own IP grievance mechanisms. So when you go to these, when you use these IP grievance mechanisms, they are good enough for you to sort of bring it to the attention of these platforms. But if these kind of startups are coming up, and and if they are facilitating the identification of infringement, so to say, I am pretty sure that in due course they will also be a part of these, you know, they're the, whatever they have unearthed or whatever they have found out will be forming a, will be evidence in the litigation. So I'm pretty sure that the authenticity of that evidence will definitely, you know, it will show up whether the courts are actually taking them seriously. So in due course, I would suggest that yes, I mean, there's no harm in using their services. But then one should also be vigilant about which ones are authentic, which ones are really helpful, and which are the ones who understand this whole ecosystem of infringement on digital, this thing, in the digital world.
I have the last one question for you. We are now dealing with AI generated content, algorithmic discovery, and domain abuse. Are courts really treating these as a new problems?
I don't think so, because this is a different technology. AI is a different technology as compared to an e-commerce platform. But are the courts dealing this in a different way? By and large, no, because at the end of the day, courts are only going to look into the fact that whether it is an infringement or not. Courts are again going to examine whether the conduct of the intermediary is relevant or not in this particular case. So yes, like for example, AI generates information and content at industrial speed. So the manner in which the infringement will be facilitated will be much faster. It will be much faster. So it will be more prudent upon the brand owners or the plaintiffs to be more vigilant about how these infringements are happening on the AI platforms as compared to the digital, the e-commerce platforms. So definitely the manner in which the brands will have to be, brands will have to look into this issue, and how they will facilitate this entire ecosystem of identifying the URLs and identifying the product and the source or the bad actor behind this is definitely going to be it's going to be a tougher challenge. But courts more or less are not going to look into these things as much as the brand owners will. And at the end of the day, the same technology which is helping the brand owners identifying is also helping the infringers in creating more and more infringing content. So deep tech or legal tech or technology is cutting across both ways. So it's not going to be easy. But when it comes down to the court is only going to ask a few questions. The same old questions I think the court is going to ask. Who is the infringer? What are the steps the plaintiff has taken to identify the infringer? Which are the URLs? Where is the source? And what has been the conduct of the AI tool or the AI platform after it was made aware of what exactly is happening?
So if audience have any questions, they can ask. Yeah.
Yeah, thanks panel for the interesting session, and thanks Rajat and the organizing committee for like getting so much of diverse speakers list today. It was really interesting in the first half. So brief background about me, I'm by profession an engineer. I'm currently working at Qualcomm and been working in embedded systems. But I also have a degree in law and specialization in IPR. So my question, because I usually interact with startup founders and new entrepreneurs. So a lot of people who are technocrats, like you have covered in this panel, and we also know about these IP stack, not just patents, but IP stack in the earlier plenary session that we had, is that it's not just patents or trademarks, but you have end user license agreements or data privacy and all of these things when you're launching an app or any of these things. And the founders are essentially do not care about these things in the initial stages because of the cost cutting, as you mentioned, or because they don't have the time for it, because survivability is key and not protection at the moment. So at this stage, and especially in India, when the founders are not really aware of the existing laws and how to protect their IP, and leave alone protecting, but how to identify the IP is a big question for them. So at what stage do they need to start protecting their IP? Is it when they get the proof of concept, or is it when they find the co-founder, or is it when they get their first series of funding? At what stage should they start protecting their IP? And my second question is, if they do want to, quickly validate if their idea qualifies to become intellectual property, like what we've seen Instant IP right now. That's one good platform. But for more serious, technically strong ideas, which can be patented. But for now, maybe patent is the long way to go. So maybe they want to just protect their idea. They want to quickly validate if their idea qualifies to be, an IP. So what can new founders take steps to identify this? Yeah. My question is to Sri Ram, by the way. Yeah.
Hi. I think to answer your question on when should they start protecting their IP, it is as soon as they are aware of what they want to protect. So they should not delay it any further, because again, whether they want to protect it in India or they want to protect it abroad. And as already Utsav has mentioned, there are various countries which are first to file jurisdictions. There are some countries which are first to use jurisdiction. Even the countries where for example, India, which is first to use, it is still advisable to immediately file. Talking strictly from a trademark perspective, if I have to say, they should immediately file an application for their trademark, irrespective of how long ever it may take to get registered, because at least they are in the queue. And they should know that irrespective of the fact that they are using it first, before another person starts using it, or before another person may have filed it, the law is still in their favor. But irrespective of that, that registration certificate is a weapon in that person's hand to tomorrow attack an infringer. So it's that additional benefit. So my answer, very simple answer, is that they should immediately do it. Now, if they are worried about costs, I think the government itself has come up with a lot of schemes for startups, and there are a lot of, I think they need to be guided more on, they need to be made aware of how to go about this. So once they are made aware of how to go about this, government has a lot of schemes, and we as a lawyers community also can take those initiatives to guide the startups and to make them aware of not just the procedures, but also the importance of doing it at a very early stage. So that's it.
Thank you.
So another last question, yeah.
Thank you so much for this fascinating panel. My name is Marcy Foucard from France, and I represent the French delegation. And I work in legal tech startup, which name is Legomnia. My question is, we see very different regulatory approaches to IP in the metaverse between Europe with, for example, GDPR and AI Act, and Indians emerging frameworks. So how do you envision cross-border IP enforcement working when a French, for example, when a French luxury brand NFT is counterfeited on an Indian Web3 platform? And what legal mechanism would bridge the jurisdiction? Please. Thank you.
For whom is this question?
If I'm not mistaken, is your question about NFTs or?
Yes. Yes, my question is about, for example, a French luxury brand, NFT, is counterfeited on an Indian Web3 platform. what legal mechanism would bridge the jurisdiction?
What are the legalities behind that?
Yes.
Is what you're asking, and it's a French person is in the NFT marketplace is infringing, and what are the how do the
Yes.
Indian courts deal with
Yes,
that?
exactly, yes.
Is the question.
Yes, is the question. Thank you.
Okay. So long as it is available, I mean, if it's accessible in India and the plaintiff is from India, the principles are more or less going to be the same. So there is not going to be much of a difference. As I've already mentioned, it is the change in technology is not what matters here. Whether it's an AI platform, whether it is a digital marketplace or an e-commerce or a metaverse or Web3, irrespective of that, it is going to the legal principles behind that is more or less going to be the same. And now the courts are also giving John Doe orders and dynamic injunctions to facilitate and in the interests of the plaintiffs whose intellectual properties are being violated.
Okay, thank you so much.